Ladies, my lords, can I just deal with one point on involving, just perhaps I should have shown you this passage. In the core volume, page 219, is the skeleton argument for the first instance hearing submitted by my clients. And you'll see at paragraph 20 what was then put before the judge about the basis for saying that involving was the correct word. And in the fourth line of paragraph 20, it said the fact that the policy has been badly drafted is supported by the fact that Churchill motor policies issued before and after the present case have used the wording of an accident involving the insured's car. It refers to Charlton and Fisher, where the court considered a motor policy for an incident in 1995, where the policy, the insuring clause was in the event of an accident involving your car. And it goes on to say the current Churchill motor policy wording found on Churchill's website states, we will cover you for your legal liability to other people arising from an accident which involves your car.
I have it on my screen at this very moment.
Yes.
That is what it says.
Yes, and that's what the current one says, yes. So just to make it clear that this is not a word of our invention to suit our case, this is actually based on the form of words that Churchill usually used and now uses, and whether this was a typographical error or not, this is not a word that you would be imposing on the insurer in circumstances where they were unwilling to use such a word.
The change of wording usually involves a change of meaning, but you say here, no. The change of wording involves the same meaning.
Well, it's changed back again, and then one looks and says, well, do they really intend to change it? And if it doesn't work, then you're asking yourself, is this an intentional meaning or is it a mistake? And when the starting premise of my learned friend's case is, well, this doesn't work to do what it was intended, I accept that, and it's got to be filled in somehow, it's not a promising start. The geographical restriction point obviously doesn't arise on our construction, but it arises on the way my learned friend argues his case. Just a few submissions on that. Our starting point again is that the clause as it stands is not fit for its purpose, whatever that purpose may be, whether it's the narrow purpose of satisfying the statute or the broader commercial purpose that we contend for. But when making good that deficiency, does one read in a geographical limitation? And there are a number of reasons why the answer to that is no. The first is, and this is in some ways rehashing some of the arguments, but for a different purpose, the essential starting premise for the argument for a geographical restriction is that it's the certificate that's doing the filling in. And that's wrong, as I've already submitted, because that should not be viewed as an additional insuring clause, but rather the insuring clause itself should be construed in order to ascertain what its intended ambit should be, and that contains no geographic restriction, and nor do the other provisions. Commercial purpose of the policy, one can see, can readily be seen to provide cover without being constrained by the minimum statutory requirements. Again, a submission I've already made, but again comes in on the geographical restriction. There's no rational basis for assuming that a geographical distinction in the scope of cover was intended as between accidents for which the insured was liable, which occurred when he was in the car, and those which occurred when he wasn't in the car. No obvious reason why there should be a geographical distinction. And if one is relying on the statutory cover and the certificate, it would also mean that where the insuring clause didn't apply, you perhaps wouldn't be able to take advantage of the enhanced property damage cover either. You'd be into the statutory cover with its limit of 1.2 million. That's also an irrational reading and construction of the policy in our submission. And the entire premise of the policy is it's providing cover without geographical restriction, except when it says so. Finally, on the construction topic, there's the application of the construction to the facts, because if we're right about involving, how does that work with the facts? Well, firstly, it was only because the car was being repaired and worked on that there was a fire, so it involved it in that sense. But secondly, submission I made in response to a question, it was in fact the source and seat of the fire. The welding itself may have been the proximate cause in terms for liability purposes of the fire. That's what rendered the insured liable, because he was negligent in his use of the equipment. But what did he set fire to? He set fire to the interior of the car, the upholstery in the car. It was the car that was the source and origin and seat of the fire, and that then spread. Now, we'll come to the significance of that on the question of use later on, because, of course, the Australian authorities talk about positioning the car. Even if repair is not use, positioning of the car is. And he positioned it near to some mats, which were inflammable, so the fire in the car then spread to inflammable materials outside it. But now, that's, unless there are any questions, that's all I wanted to say about construction and the application. Now turn to the statute. There are two separate topics, somewhat elided in the course of Learned Friend's oral submissions, and in his case, very separate topics of use and arising out of. But there's an introductory part to that, to both of those topics, and one arises out of the criminal liability implications, which Learned Friend alludes to, of what he says is our submissions. Now, it's important to bear in mind and have a look at the scope of Section 143 of the Road Traffic Act. That's in the Bundle 1 of the Authorities, tab 2, page 458. And the criminal offence arises from using 1A, must not use a motor vehicle on a road, and B, must not cause or permit another person to use a motor vehicle on a road. Unsurprisingly, the criminal offence that's created is a specified act, namely using on the road in the absence of insurance. If you don't use a vehicle on the road without insurance, you don't commit an offence under this section. I'll come to 144A in a moment, but you don't commit an offence under this section. And that's why, if the mere fact that Mr. Holden was carrying out repair work on private property would not of itself be a criminal offence if he wasn't insured for it, because he wouldn't at that moment be using it on a road. So you don't have to worry about the criminal implications of repair work on private property. If you're repairing it on the road, of course, there's every reason why you should have insurance for doing that, but I'll come back to that. Unsurprisingly, when Parliament came to what you have to insure against, they expressed the insurance requirement more expansively. And that's at 468, section 1453. It's insurance in subparagraph A in respect of the death or bodily injury to any person caused by or arising out of the use of the vehicle on the road or other public place. Now, the fact that the insurance policy, just in those terms, may give you broader cover than the circumstances in which you would commit an offence, isn't an issue. But my learned friend tries to make it such. He tries to say, well, if you give an expansive meaning to 1453A, you're expanding criminal liability. You're not, because the criminal liability is very closely circumscribed in 1431 to use on the road. You mustn't be using it on the road without the insurance. The insurance you must have is an expensive one. If it only covered you for use on the road, you would be committing an offence because it wouldn't be the required insurance, but your act would be using the vehicle on the road without the statutorily required insurance.
Wasn't he submitting that you should be cautious in giving a very generous meaning to use?
But the criminal offence is only use on the road.
Yes, but
And
it's still
so-
use.
Yes, well, I'll come to that, because I'll be submitting that there's every reason why someone repairing a vehicle on a road should be regarded as using it, because it creates a very real hazard. Changing a tyre and the tyre rolls across the road, why shouldn't that be use? But anyway, the mere fact that your vehicle is on the road would be use. So it actually doesn't arise, because to be repairing it on the road, the vehicle must be on the road. And the authorities tell us that merely having a car on the road, even if you can't move it, is use.
What about a car and a transporter?
I hadn't thought about that one. I will confess. But whether it's on, I'm not sure whether that would be on the road if it's on the back of a lorry. But in any event, none of this really matters, because now you actually, under 144A on page 465, if you're the registered keeper, section 1, 144A1, you have to have insurance anyway. So it doesn't matter whether it's on, if your car is parked in your garage and not on the road. Nowadays, if you are a registered keeper, you have to have insurance, unless what you have done, and this is one of the ways you can get out of having to insure, is subsection 5, registered keeper in C has by the relevant time completed with any requirements under subsection 7A that he's required to have complied with, 7A, to make such declarations, and that's called the statutory off-road notice. So what you can do, if you're the registered keeper, you are committing a criminal offence if you do not insure, even if the car's only parked in your garage, unless and until you make a statutory declaration that your car is off the road and will remain off the road. So actually, the law has tightened up now and is perhaps recognising what we say this policy recognises, that cars are hazardous things. And they're hazardous things which need insurance, and unless you can get that qualification, it's never going to be used on the road. Now, whether that's compliant with EU directives now, because you have to have, under those, you have to have insurance even for private land use, is another matter, but I was just looking at the criminal implications. That's what I wanted to say about the criminal issue. There really isn't a criminal consequence here. Because, as I said, repair on the road, you're already using it just by the mere fact that the car's on the road anyway. So this is purely an insurance issue. So use. Let's turn to that. Quite right, there's no English authorities on it, and maybe because insurers haven't previously sought to take the point that repairs aren't use. It may be this is the first case of its kind, who knows? Impossible to speculate. An important point, learned friend tries to tie use into the European directives. We say that is wrong as a matter of principle. Use is an English law concept which dates back to the Road Traffic Act 1930. In particular, sections 35 and 36 are the forerunners of the current legislation, and they use the same formula for the requirement of insurance and for the criminal offence, subject only to the later addition of public place to road. Now, I should say that unfortunately only section 35 appears in the bundle. If you want to see section 36, I'm not going to take you to it, it's in the same form, but you'll find it in set out in Romford, Ison, Lister, tab Authorities Bundle 3, tab 34, page 1014. And there's a little footnote which sets out section 36 of the 1930 Road Traffic Act.
I'm assuming that that was a UK statute,
Yes.
so it's not just an English concept.
Yes, I'm dealing with an English. When I say English law, I mean in contrast to European law. It's a
Yes,
British.
but
a
in
British
this
concept.
court we
Right.
appreciate that
Yes.
the United Kingdom has 3 separate jurisdictions in it, and 2 of those jurisdictions do not appreciate it if United Kingdom concepts are referred to as English concepts.
But, my lady, I will confess to not having checked whether there was separate legislation for other parts of the United
Strikes me
Kingdom.
very unlikely as it's
Very
currently a
unlikely.
reserved matter.
Yes, very unlikely. Well, but back in 1930 is what I was talking about.
Even more unlikely.
But I will assume that it was the United for all of Great Britain. But I'm afraid only qualified to practice in and make submissions about English law.
Well, in 1930, there only was one parliament in these
Yes,
islands, and that was the UK one.
But they did sometimes legislate for separate parts of the.
They did, but road traffic, as
Yes, quite.
the lady says, is a UK-wide phenomenon.
Right. Well, I'll force of habit say English law rather than British law.
It is, but it's the sort of thing you get picked up on. In this.
Quite right, and quite rightly so. But maybe my
Anyway, let's not take up any more
limited
time
field
with my frivolity.
my limited field of practice coming to the fore. If the concept of use under the Road Traffic Acts is narrower than the EU directive, of course, insofar as possible, it must be read up to be consistent with it. But if it has historically been construed in a way which would be broader than the EU concept, then, and it goes further than the directive, it must be applied as it stands. And that's where we say there was an error in His Honour Judge Waxman's approach at page 169, paragraph 60. And the same error, we say, pervades my learned friend submissions, because he simply applied the Vanook test and rejected the Canadian approach because he said it was too broad when compared to Vanook. And we say that that's wrong. It assumes that this is implementing legislation. If it was implementing legislation, then that may be right. But if it's legislation which in fact simply continues to adopt the historic formula that was used back in 1930, maybe with other modifications to take into account the directive, but these words remain as they were in 1930, the inference must be that the intended meaning was whatever the courts had construed that to be, or a common law court would construe that to be, and not the EU meaning.
Provided it's broader.
Provided it's broader,
Yeah.
yes. But one starting point ought to be not to put the EU directive to one side, construe it, decide on its ambit by reference to all relevant authorities, which would be British authorities and Commonwealth authorities insofar as they used similar concepts, and then ask oneself, is that meaning narrower than the EU meaning? If so, we need to go and have a look at the EU meaning. If it isn't narrower, then you just put the EU meaning to one side. It's just irrelevant. As long as we're we've done the minimum, doesn't matter if we do more. So let's look at the authorities that we have, and I think probably take this quite quickly because a lot of it seems to be uncontroversial. English authorities, you'll see from our case, the Master of the Rolls judgment refers to them, but we have Elliott and Gray, which talks of having the use of. And Plumbian and Vines, which make it clear that you have the use of something, you have the use of a motor vehicle, even if it's incapable of being moved. You still have the use of it. And that's where my learned friend's example of the fridge and the computer are totally inapposite. Because your fridge may be sitting in the shed, unused, unplugged, and you wouldn't say you're using your fridge. But your car can be parked on the road, incapable of being moved. It's had any bits, maybe it has a carburettor removed, its brakes are seized, it cannot be moved, but you're using it. And it's a statutory concept, but you are using it. So these sort of superficial examples may sound attractive, but they just simply do not work. It's a very different concept in the statute. It is have the use of. Of course, if your fridge is sitting unplugged in the shed, you have the use of it, but you're not using it. You're not actually using it. But have the use of is sufficient for the statute. And then we have the restriction on that concept in Brown and Roberts. All of this is dealt with in our case, where you then pose the question as to whether a passenger opening the door is using the motor vehicle or has the use of it. And the answer is that the passenger doesn't, because the passenger has to have, have the use of it, you have to have the control, management, or operation of the vehicle. And merely by having the control, management, and operation of a door, you don't have the control, management, and operation of the vehicle. And that means it's very important to bear in mind that the driver opening the door is very different from the passenger opening the door. It's doing the same thing, but one is using the car because he's opening the door in circumstances where the driver is, when he opens the door, is using it in circumstances where he has overall control, management, and operation of the car, but the passenger only has control of the door. Same thing, different statutory conclusion.
Listening to you slide from use to has the use of, I've been looking at your case, and it's quite clear, and I think you've more or less been saying this, the notion of has the use of is intended to help decide whether somebody's got operation control and management,
yes,
which is a slightly different issue.
Yes, but use.
So let's come back to use rather than have the use, if we're not dealing with operation control or management.
Well, the reason have the use came in because the defence, and these were, I think, criminal cases, some of them were, the defence was, I can't use the car. It's not capable of being used. And therefore, I've not committed the offence of not having insurance because I physically can't use it. It won't go. And it's going to take a lot of work for it to go. And that's the Plumbian and Vines case, to which the court says, well, it doesn't matter because you have the use of it. So that's not about control, management, or operation, the control management or operation bit really comes in because you've got to distinguish between someone who's washing your windscreen,
Well, quite.
someone who is changing a tyre for you. They're not, they might be your agent for and so you might be liable if they're negligent when changing the tyre, but they are not using, and they don't have the use of the car when changing a tyre for you. So I think that, my lord, is the distinction that we seek to draw. Now, the directives, they say use, as interpreted by the court, any use which is consistent with the normal function of the vehicle. I just wanted to refer to one passage in Andrade, which my learned friend didn't go on to. It's page 1096. It's in the third volume. And at 13, this is tab 38, sorry, 38. At page 1096, paragraph, the end of 38. My learned friend referred to the words at the end of 38, any use of a vehicle as a means of transport. But one has to be careful with those words because what they were doing was distinguishing use of a vehicle as a means of transport as opposed to use as a machine, to do as a piece of equipment, which is what was happening there. And that wasn't, it plainly wasn't intended to detract from the Vernuk test, which had already been referred to, which is any use which is consistent with the normal function of a vehicle. And that's rather confirmed by the next paragraph, where it says, in that regard, the fact that the vehicle involved in the accident was stationary when the accident occurred does not in itself preclude the use of that vehicle at that time from falling within the scope of its function as a means of transport, and therefore within the scope of the concept of use of vehicles in Article 3.1 of the first directive. Further, whether or not its engine was running at the time when the accident occurred is not conclusive in that respect. And I think the common ground for the test under the EU directive is, as expressed in Vernuk, any use which is consistent with the normal function of the vehicle. So, and that's why we say repair is, because it's a use which is consistent with the normal function of the vehicle as a means of transport. You're repairing it in order to get you from A to B. I'll develop those submissions in a moment. Now, my learned friend has made some submissions about this. He said that, in his case certainly, that the European Court of Justice decisions require the car itself to be the cause of the accident. But I think I've already dealt with the point in earlier questions that when we're talking about the cause of the accident, one means involved in. One means that the car may be the physical cause of the accident, in that the car has hit something, or it's caught fire and set fire to something else, as where sometimes cars do unfortunately catch fire due to a defect in their engines. It can be the cause in that sense. But in the context we're talking about, liability, there will only be a liability if the insured has been guilty of some proximately causative negligent act, such as not maintaining the car properly so that it catches fire, not applying the handbrake so the car rolls down and causes damage in that sense. And as I've already made the submission in other respects, the car in this case does have a very strong causative role in the damage because it was combustible materials in the car which formed the seat of the fire, which then developed in the car and then spread outside. And thirdly and finally, given that under both the Acts and the EU directives, use is not limited to driving, but extends to leaving a car parked, and even a parked car that's incapable of movement in the immediate future. There's no obvious reason why repair work, to ensure that a vehicle can continue to be driven, should not be use of it as the master of the rolls held. And that, in fact, is the conclusion that has been reached in Canada. And learned friend has tried to distinguish those cases on the basis of different language, but they aren't distinguishable with respect. I mean, one court may choose not to follow them, but they are not distinguishable on any basis at all, we submit. They were addressing the phrase use or operation. But in circumstances where it's well established for the purposes of the Act that operation is not required for the purposes of use, the inclusion of that additional word in the Canadian context is of no materiality, because they're saying, well, all these cases that we're actually looking at are cases where the car wasn't being operated. And the question is, was it being used when it was being repaired? Now, it's right to say that Stevenson and Reliance, which is the source of the jurisprudence, was not a case on repair. But what it was, and significantly, it was a case on delivery. What happened was the driver of the fuel tanker was delivering the fuel from the tank into the gas station tanks, petrol station tanks. And he did that negligently, and there was a fire. Overflowed, there was a fire. And the question was that use of the vehicle as contemplated by the Canadian provisions? And the answer was yes, it is use. It's not the use of the vehicle as a means of transport, but it's use of the vehicle. And I'm not going to go laboriously through the authorities, but I just wanted to refer to one of them, which is Elias, because of something learned friend said about it. And
Isn't it as a means of transport? Because this was a tanker which was carrying the gas, as you put it.
Yes, quite.
Yep, so it was,
Yes, but what was happening what was said was at the time it wasn't being used. What was happening was that
it was discharging the gas it was
discharging
carrying.
the gas it was
That
carrying.
sounds as if it might be ancillary to carriage.
Oh, I quite agree. Yes. Well, but they didn't do it on the basis of arising out of. They did it on the basis that that was use, and that was the Supreme Court of Canada. Mm-hmm. All of them saying this is use. It's not arising out of use. It's use. And that was the source of the decision in Elias. Now, it's right to say that there was one basis of decision, which was ownership, but the judge, and this is at 1173, letter F. And the judge says, moving on to use or operation, repair is not operation, but in the words of Mr. Justice Rand in Stevenson and Reliance, use means the ordinary and well-known activities to which automobiles are put. And that was the phrase, because he was saying the ordinary and well-known activities to which a petrol tanker is put include not just getting from A to B, but also discharging. And it then said that definition had been found in the case to have a broad meaning, including, for example, siphoning gasoline for use as a cleaning agent and for use as fuel, modifying wiring, and preparing for maintenance. The case requires there be an unbroken chain of causation between ownership, use, or operation and the injury. The work being done went to the use of the vehicle. And the repair work, very similar to this case, a spark from a welder used by the plaintiff set the vehicle afire. The fire spread through the building, causing extensive damage. That's on 1170 between F and G. So it's almost identical to this case. And what the judge says is the work done went to the use of the vehicle. It was not repair work without which the vehicle was immobile, unsafe, or underperforming. So the facts aren't as strong as this case, because this case, it was going to fail its MOT unless this work was done. But it was consonant with, and not severable from, its use during a hoped-for period of long service. Prevention of deterioration by a family member is an integral part of use. Repair work need not be necessary to immediate drivability to come within the meaning of use in the regulation. The law cannot be drawn so fine that it distinguishes between one sort of repair and another, say changing oil and fixing potential rust spots. And one then sees that line of authority developed in Canada. It's set out, as I say, in our case in the judgments of Lord Justice Henderson. It's also, the cases are all very helpfully summarised in Pilitarium Priore. That's Bundle 3, Tab 50. I don't think time permits me to go through them all, but there's a range of repair cases, and it's all fairly DIY repair by householders.
Could you please give me a page reference to the last reference?
Pilitary, it's tab 50, and the cases are summarised at 1214 to 1219, my lord. And then there's also 1220 to 21, where he talks about causation. And I just, if we have, maybe just turn that, and I'll try and just pick out snippets from it rather than going through it all. 1214, he talks about the purpose test, what's being done, and he goes through all of the cases, as you can see, from the pages on from 1214 to 1217, and he gives some exceptions at H, and that's what I wanted to refer to. At letter F, subparagraph H on 1217, says exceptions to the purpose test, the use to which the automobile was put was not an orthodox or well-known activity, e.g. when a fire was caused by a cutting torch in the process of transforming a vehicle into a demolition derby car. That is not in the normal part of the normal orthodox well-known activity of repairing cars. Another one where sleeping occupants were asphyxiated by carbon monoxide from a lit hibachi. That was not a normal use of the van. And he also looks at causation at 1220, and at letter H on 1221, he refers to the fact that the Automobile Insurance Council submitted that in the case at bar, the vehicle was a passive participant. It was merely the subject of work being done negligently by the defendant. I disagree, because the repair itself was a use of the vehicle within the meaning of the policy, as I earlier held.
Have you dealt with Mr. Eklund's basic point, Mr. Edelman? You're giving us extensive and valuable submissions on what use means in various statutes. You've taken it from section 145.3a, and Mr. Eklund says, you can't pick and choose, Mr. Edelman. This is use of the vehicle on a road. What's happened to the on a road bit, he says?
Well, that's why this submission is on the premise, firstly, that you've rejected my involving construction, and secondly, that you are instead adopting His Honour Judge Waxman's construction, which did not have a geographical limitation. So that the third construction is you get His Honour Judge Waxman's construction plus the geographical limitation. If you don't have the geographical limitation, then you don't get into the question.
No, you don't. No, you don't.
So that's why I was making the submissions about the geographical limitation. if there is a geographical limitation, I accept that my own, and I'm in Judge Waxman territory, so it's in the car or using or arising out of the use of the car with a geographical limitation, I accept that my route to success can only be through arising out of. And that's why we've run that argument as well. I quite accept that if there's a geographical limitation on the use because Mr. Holden wasn't in the car at the time it caught fire, and the only cover under the policy is subject to a geographical restriction, none of this matters. This is all.
Thank you for clarifying that.
Yeah, maybe I should have clarified that in my oral submissions at the outset. We tried to clarify it in the case, but it's... So that's the premise of all this, that we have no geographical restriction.
Thank you.
The Australian cases, right to say that although there's potentially some tension between them, the balance appears to be against holding repair as use. And they don't follow the Canadian line. But what they do, perhaps to ameliorate the fact that repair itself is not use, they say that negligent positioning of the car in order to carry out repair can be use. And the classic case of that is Clement and Clement, which is in your bundle at tab 43, third bundle, starting at page 1154. In that case, the car was negligently jacked up and collapsed and injured someone. And if we go to what the judge said about that, I'm sorry, I've turned up the wrong page in my notes. Here we are, tab 43. I hope I said 43. He says on page 1160, I think is the best place to do it, about halfway down the page, those events, starting the paragraph above. In this case, submission has been made on behalf of the plaintiff and defendant that I should find that the plaintiff's injuries did in fact arise out of the use of the motor vehicle. It's been submitted to me that I should look beyond the repair or servicing operation that was going on at the time of the accident to events prior to that time, but nevertheless connected with the accident and the injuries. Those events consisted of driving the motor vehicle by the first defendant to the position on the driveway where he intended later to carry out the servicing operation, and his parking of the vehicle in that position. It is put that the positioning of the vehicle was a major contributing factor to the accident. Of this, there is no doubt. The evidence to which I have already made reference clearly establishes that the positioning of the vehicle was productive of the slipping of the jack and the vehicle. It is put that the driving of the vehicle and its positioning in this way was relevantly a use of the vehicle from which the plaintiff's injuries in substantial measure arose. I've come to the conclusion, etc., I should accede to this submission. I consider it has been established on the fact that the plaintiff's injuries did arise out of the use of the motor vehicle in the manner I have just set forth. So the use was positioning. And that's of significance because you'll have seen from the agreed statement of facts, this is page 50 in the bundle, paragraph 6, that the fire spread from the car and set alight some rubber mats lying in Phoenix's premises close to the car. That's the third sentence. And you'll also see that one of the allegations by the appellant in their defence to the respondent's claim, this is at page 198, they're alleging contributory negligence. 198, paragraph 16, subparagraph 6, is that my clients were negligent, subparagraph 6, in failing to ensure that Mr. Holden had taken sufficient safety precautions before commencing grinding or welding by positioning his vehicle in such a way that if a fire did occur, the fire would not spread to combustible material in the vicinity of the vehicle and or in failing to ensure that combustible materials have been removed within the vehicle and from the vicinity of the vehicle. So certainly the positioning of the vehicle near to these rubber mats is said to be an important fact. So even if one was to adopt the narrower Australian approach to use, they still take into account the fact that you may have carried out the repair through negligently, in a way that was negligently positioning, involved negligent positioning of the car. And so that negligent positioning is use, and an accident which is caused by or contributed to by that, or damage that is caused or contributed to by that negligent positioning arises from that use.
Please remind me, did the trial judge deal with that submission? Did Judge Waxman deal with
I
that?
don't recall it.
No, I don't think he did.
I mean,
Because he was just applying the Vanook approach, and he regarded everything else as being irrelevant. That's the error of, we said it was the error of his approach, because he just simply asked himself the European directive question. Now, I'm not saying that wouldn't lead to the same answer, we just don't know. The European jurisprudence on this isn't very developed.
but was evidence led as to whether or not the positioning of the positioning of the vehicle that it was negligent in the trial? Was that an issue?
No, not as far as it wasn't whether there was negligent positioning of the car, but in this sense, it's a question whether it was, as a matter of fact, did it cause the fire? Because if the damage arose from in part the positioning of the car, there was causative relevance to the positioning of the car. In whether that was in fact negligent or not doesn't matter, because that's not what the statute is asking. It's asking whether, or the policy which we're posing, is it a liability that arises from the use of the car?
Yes, I see that, but was there any evidence focusing precisely where the car was placed in relation to these mats or anything of that nature?
Ask about that, because I'm new in for this at this level.
Well, the judge doesn't make that point in paragraph 2 of his judgment.
No. Well, his statement was in evidence, and I don't know really, that dealt with what actually happened. It is electronic. 424. Let me have a look.
Yes, so all we know is that there were rubber mats close to the car.
Yes, well, we've got the statement of fact. The statement of fact actually tells us, and that's the agreed statement of facts, at page 50, which tells us the sequence of events. Yeah, and the judge does deal with the mats. He does make a finding about the mats in paragraph 2.
Yeah, that's what I was looking at.
Fire spread and set alight some rubber mats lying close to the car.
Yes, but it's not said it's negligent.
No, because of course he's not actually dealing here with the issue of negligence. He's dealing with the question of, this isn't it wasn't, he was dealing with the insurance issue. Because the action was seeking a declaration of policy. It was by the appellant seeking a declaration that the policy doesn't cover the claim. So in that sense, it wasn't a case of proving whether or not he was negligent. Everybody assumed he was. It wasn't in dispute that he was negligent. And the question is whether the negligent way in which he carried out the repair was something that was covered by the policy or not. So it wasn't necessary in that sense for the judge to make findings of negligence in accordance with these particulars. But we say that as it so happens in this case on the facts, the car was positioned, we know, close to combustible materials. That was actually an allegation of negligence against, contributory negligence against my clients. So we say the positioning of the car in this case is a factor and is use.
But there may have been an assumption, understandable assumption, that if you're welding and you set fire to your car, that there's been, and burn something next door, there's been negligence. But there hasn't been any findings as to whether that negligence was the positioning of the car rather than the way he carried out the welding. I think that must be the case.
Well, the way in which he carried out the welding was negligent, so
yes.
It wouldn't be whether that was negligent or not. It's a question whether he was also negligent when he was preparing for the work before he started it, start doing the work in circumstances where there was a fire risk next to combustible material.
Well, you would like to suggest that positioning had a causative effect on this,
yes,
because he drove it into position.
Yes.
And so that's easier for you.
Yes.
But without a finding that the positioning had some causal nexus with the fire and the spread of the fire, you can't make much of it, can you,
Well,
Spiegelman?
we do have that. We have the agreed statement of facts because we know the fire spread.
As a result of the positioning?
Well, the fire spread from his car and set light some rubber mats lying in Phoenix premises close to the car. Mm. And the car, the car was the object which we all know was moved, because there's a sequence as to what he did. He drove the car into the loading bay, disconnected the car battery. There's a statement of facts tells us what he did. So we know that he drove the car, positioned the car to where it was, and that was in fact close to the rubber mats. And we know that it was the rubber mats which caught light after he set fire to his own car. So the causative significance of it is all there in the agreed statement of facts.
Could I just pursue the topic in a slightly different direction? I put it to the appellant that maybe there's a concept of acts preliminary to use, because as we can see from the statute, use doesn't cover everything. You can be a keeper without using a vehicle. So I wondered if you would give some help at what point in time, relevantly to this case, use begins.
Well, the statutory concept of use is to have the use of it. And it's only, of course, that's qualified by having the use on a road for the purposes of the criminal offence and the requirements of the statute. But actually, as long as you have the use of the car, you are using it for the purposes of the statute. And the geographical limitation is only something that comes in for the purposes of criminal responsibility in the scope of the insurance. It doesn't change the meaning of the word use. It just qualifies the circumstance in which use without insurance is a criminal offence.
Then I'm not sure why Parliament went to the trouble of enacting Section 144A, because as long as you've got the keys, you use it on your submission.
I think that was to deal with the fact that they wanted to make sure that someone was insuring and to control it.
Absolutely, even if they weren't using it.
So if you are the registered,
Suppose you've got a classic car and you just keep it in a museum or a garage.
Well, you still have the use of it, unless you do a statutory off-road.
That is your submission, yes. So Mr. Kipling's car in a museum would be, have use of it.
Well, you don't have to. It's not an offence because it's not being used on the road. But as if you're the registered keeper, you do have to have insurance unless you've done your statutory off-road declaration. And of course, if it's in a museum, you would do a statutory off-road declaration.
But then you've got the car on the transporter at some point.
Yes.
There must be preparation for use, and that must be a stage which comes to an end, and then you use.
That may be, but that's not how the repair works, because we say you are actually using the car, repair is use, but even positioning it for repair is use. That's not,
That's on
the
the
Australian
Australian,
case is
yeah.
not preparatory. That was the whole issue.
But maybe this is one of those words, like, as in Brutus and Cousins, with its criminal statute, you must use the word use as a matter of common sense,
Well,
rather than technical. Anyway, there we go.
bear in mind that the mere presence of the vehicle on the road is use. And once you start from that premise, then actually, whether you're working on the point I was making earlier, saying that repair is use doesn't really add anything to the scope of the criminal statute, because you are, if the vehicle's on the road, it's on the road anyway, and you have to have insurance for it. But what it may, the only thing it may do is it may enable insurers to wriggle out, because they may say, oh, well, changing a tyre was something different. When you were changing the tyre, you weren't then using the car. Yes, it's right that the car itself was on the road, but changing the tyre so that the tyre rolls across the dual carriageway and causes a terrible accident, repair work isn't use.
But it can't turn on the consequences. There must be some analysis of what you're actually doing. And changing the tyre when you have a puncture to a rubber tyre is a perfectly ordinary incident of using a car. Welding a piece onto the chassis may be something of a different quality.
Well, it may be something of a different quality simply because most
Maybe,
of
yeah.
us in this room don't know how to do it. But, I mean, I did
Speaking for myself,
actually do
perfectly
welding
true.
at school, so I don't know if I could still remember how to weld, but I did do metalwork, so I think I could weld something, but it may be what school you went to, what upbringing you had, as to whether welding is something in the ordinary course, whether you're limited to changing
But you
tyres.
wouldn't seriously say that welding a piece onto a car is an ordinary incident of using a car?
It's what people do.
Well, that doesn't make it ordinary incident. Thank you.
Well, maybe not from our perspective, but we mustn't, maybe within our restrictions in this room, it may be that none of us could go
Well,
further than changing a tyre.
Is there any
But other
evidence?
people do it, particularly people who haven't got money to go to a garage.
Well,
to
that,
get
of
it
course,
done.
I accept they do their own repairs, but is there some evidence about how often people would do this?
But that, in a sense, lady, that's
Well,
not
it's
the
a yes or
relevant.
no
That's not the relevant question, because the relevant question is doing a repair to your car, however rudimentary or sophisticated, use of your car, and it can't turn on whether it's a rudimentary repair that everyone can do or a more sophisticated repair that fewer people in the country can do. It either is or it isn't. Now, there may be a situation where, if, for example, this was being transformed into something completely different, one's saying, well, it's not actually using the vehicle, and that the example of changing the car into a Derby car in the Canadian cases. But otherwise, one does get this curious situation of, if you're of use, or what if you change the tyre on private land and the wheel, you pull into a driveway to change the tyre and the tyre then rolls across the road? And is that...
Well, I think you're not considering the additional concept which has been suggested of ancillary acts to using the car on the road.
Well,
maybe
because of time being limited,
Indeed.
I should perhaps move on
Absolutely.
to that topic, because that's the separate topic of arising out of. And the question is, does one apply a narrow or broad causation test for that? And again, I've only got 15 minutes left, so I'm going to have to deal with this. But we've dealt with it fully in our case, and it's not really been, in our submission, responded to by my learned friend. We've got the line of authority, which is from the High Court of Australia in Green and Lloyd through to Dunthorne, and AXN and Warboys in the formulation of the test, applying the broad causation test. And then you've got this other line of authority, the narrower line, which starts off with Romford Ice and Lister. And I just wanted to emphasise one point in the list. I'm going to have to be very selective with how much I look at. But tab 34 is in bundle 3 is Romford, Ice and Lister. And remember, we're looking at the words caused by or arising out of. And what Lord Justice Romer says about it on page 1045. And he says, right at the top of the page, third line down, an accident is caused by the use of the vehicle on a road if it runs over a pedestrian at zebra crossing. An accident arises out of the use of a vehicle on the road if it skids off the road and injures a pedestrian who's walking on the pavement. Well, in my estimation, that's saying the same thing. In both cases, the proximate cause is something that happened on the road. If one was to say a car has skidded off the road and injured a pedestrian walking on the pavement, could one say about that that the injury to the pedestrian was proximately caused by use of the vehicle on the road? Of course, because it skidded on the road, and that's why it went off and hit the pedestrian. So he's giving absolutely nothing at all to the words arising out of. And one sees this more starkly in a later case, Inman and King, and I'm sorry to jump around in the bundles, but this is tab 26, because it's done alphabetically, not thematically. Makes it easier to find the cases, but then jumps around a bit.
It's a great deal easier for us.
I know. It has its advantages, obviously. Page 904. This is the motorcycle case. He'd taken a run-up on the metal path and then leapt off a bank on private property. And the test that is applied by the Court of Appeal at, you've got the numbers down the side just below 24, on page 904, and it says, in other words, it was not the use of the motorcycle on the metal path that inevitably caused the incident, but what Mr. Kenny chose to do once he left the metalled path. Of course, the accident would not have happened but for Mr. Kenny's use of the metal path to get up speed. However, the but-for test is not sufficient in my judgment to establish causation. So the test there is of inevitable causation, which is perhaps proximate cause. Maybe it's even stronger than proximate cause, but it's certainly not giving anything at all to arising out of. Essentially, doing what one can, it's actually saying that that he had the chance to stop. It was possible for him to have stopped, even having taken the run-up on the road. He could still have changed his mind and not done the leap off the bank. And so it wasn't inevitable when he left the road that he would cause the accident. But whatever the outcome on the facts of the case, the language does absolutely nothing for the words arising out of. And it follows faithfully, perhaps, the approach taken in Romford, Ice and Lister, where Lord Justice Romer drew no distinction between the two words in the circumstances he alluded to. So that's where the authorities, that's the competing line of authorities. And then, of course, we have Lord Justice Denning's dissent in Romford, Ice and Lister, and of course I accept it's a dissent and it wasn't followed. But actually, his approach is consistent with the Dunthorne and Bentley line. And the two lines of authority are, with respect, utterly irreconcilable. Because they both, because they ascribe a fundamentally different scope to the words arising out of. The reasoning in the Australian case, which had exactly the same statutory form that we had, the reasoning in that case, which was adopted in Dunthorne and Bentley, was that caused by and arising out of are used as in juxtaposition to each other as alternatives, and arising out of is a word which is inherently capable of a broader meaning. And one assumes that Parliament wasn't intending to be repetitive, and one adds into this ingredient, remembering that this does not impact on criminal liability. As long as the insurance is in the statutory terms, you're fine. But of course, the public interest would be in favour of broader cover. Because for the reason, the submission I was making earlier, motor vehicles are hazardous things. The way in which they can kill and injure people or damage property is perhaps limitless. And so if there is to be insurance, one would expect Parliament to have intended a broader rather than a narrower scope of cover. And you end up, if you take the narrow approach, you end up in the sort of case with, like Randall and MIB, which is at tab 32 in the second bundle. You end up having to have, on the narrow approach, a minute analysis of where the wheels were. Because although the man who was trying to prevent the vehicle leaving was in fact run over by the rear wheels which were on private land. And the decision turned on the fact that the front wheels were on public land, on the road. And the major part of the lorry was on the road. And so this was use on the road. Well, if the lorry had been a few yards back, no insurance, even though it's doing a journey, as in Romford, Ice and Lister. It's come off the road. The whole purpose of the vehicle is it's doing a journey, as this was Lord Justice Denning's approach. He said, well, it's arising out of its use on the road because the sole purpose of its journey on the road was to go and make a delivery, and then after the delivery it was going to go back onto the road, and this delivery was incidental or ancillary to its use on the road. Instead, if you don't adopt that approach, you get this perhaps rather startling distinction where it's all down to tape measures and precisely where the vehicle happened to be when this accident occurred, which would be purely fortuitous and haphazard. And of course, it doesn't affect the criminal position, because it's only if it's incidental or ancillary to a journey on a road that it arises out of use on the road. And for the use on the road, you have to have insurance. And as Lord Justice Denning said, as he then was, he said that it would make no difference. It would be different if what in fact happened was the vehicle was permanently on private land and was just, for example, used for delivering fodder to animals. That was his example. And then it wouldn't be incidental or ancillary to any use on the road. One other point is divergence with the directive. As you know, the directive requires insurance to be on private land. I don't challenge the proposition that our statute cannot be read without the words on a road or public place. You can't just ignore those words. It is non-compliant, and there's nothing we can do about it. But what we can do, what the courts can do, is to try to minimise that divergence insofar as it properly can on the wording of the statute. And the way you can do that is by reading the words arising out of in an expansive way to allow for example, Lord Justice Denning's case. That doesn't eliminate the inadequacy of the statute, but at least it reduces it. And so we come to the facts of this case on arising out of. If, as we submit, repair is use, or the positioning of the car in order to repair is use, and there's no geographical limitation, the damage to the property caused by the fire arose out of Mr. Holden's use, and that shouldn't be difficult. But in line with Dunthorne, one can also go further and say, well, even if there is a geographic restriction, what Mr. Holden was doing here was trying to make sure that his car was roadworthy and could be used on the road. What he was doing was, in fact, incidental or ancillary to his use of the vehicle on the road, just as much as it would be if someone had a puncture and pulled onto private land, such as the opening to a farm driveway, in order to change a tyre. It's a more complex job, but it's just exactly the same thing, a repair in order to be able to continue to use the car as a form of motor transport.
So you're seeming to, here, in this alternative suggestion, you're looking at use actually in the future.
Yes.
I thought you were also looking at it in the past.
And the past.
He's been using this car
Yes.
so much that it needs these repairs.
Yes, it's past
Can you put
and
it that
future.
way too?
Yes, of course, because it's incidental or ancillary to his use of the car. This is, perhaps I say, as a user of the car, doing running repairs is what one has to do. The extent of the running repairs one does may depend on one's ability and mechanical
so you can get it
sophistication.
either way. You can get it because past use on the road caused corrosion,
Yeah.
or you can get it because the purpose was to return to the road.
Yes, exactly. So this is all incidental or ancillary to use, and so this works. The other point about the Dunthorne test, and you see this in AXN and Warboys, whether the result of that case is right or not is another matter.
The Warboys case.
The Warboys case. But what Mr. Justice Silber there applies, I haven't got time to go to it, but it does actually apply a purpose test. And and that's how he found against the claimants in Warboys. Well, what was the purpose of what he was doing? Was it anything associated with use of the taxi? And that's where concomitant cause may come in, because it was merely the setting. The taxi was merely the setting in which he did what he did. So we're not getting into that. But here, the car isn't the setting. It's the very reason why he's doing the repair. And he was looking at the purpose, and again, that's why the Bentley case may be the judges may have thought a borderline case, because they weren't entirely sure about the purpose of her crossing the road and the time lag and so on. But if you're satisfied that the purpose of what someone is doing is associated with their use of the car, then it should be regarded as incidental or ancillary. Whether it's going to get a can of petrol because you've run out of petrol, pulling onto a private driveway to change a tyre, or taking it to your employer's workshop so you can work on it after hours. Those all arise out of the use of the car on the road as part of its normal function. I think running out of time, so there was just one more brief topic I think I had to deal with, and that was the social and domestic point. It was never said below, as I understand it, that Mr. Holden was not using it. If he was using it, was not using it for social and domestic purposes, or hadn't used it for social and domestic purposes before, and wasn't using it for social and domestic purposes in the future. And that would be for the insurer to assert and prove that it fell outside the excluded use. But obviously, there are going to be difficulties as to the application of that test. What if you have the car parked outside your house for 6 months? Is it social and domestic? If you have previously used it for a non-permitted use, how relevant is that? There are always going to be these difficult questions. The only thing I would say is, if there was only cover for social and domestic use, giving it to a garage repairer, they would be repairing it for commercial purposes, not for social and domestic use. So if the policy was restricted to use by the insured or anyone else for social and domestic purposes, it doesn't cover the garage repairer when they are actually repairing it. Because it's not, their purpose is a different one. And of course, the insured wouldn't be liable for their negligence because they're independent contractors. I had to take the last bit as a bit of a gallop, but I hope I've sufficiently covered the territory. I wanted to allow my learned friend sufficient time for his reply, unless there's any matters I can help the court with.
Well, thank you very much indeed, Mr. Edelman. I think no further questions. Thank you. Mr. Harrison?
Excuse me, go back to dealing with the contract interpretation points first, then come to use. And the first point is simply that the add-on covers that one sees in the policy, the add-on covers that one sees in the policy don't give you any assistance whatsoever as to the scope of the liability cover. This is a policy which is a comprehensive policy, which is intended to give cover to somebody for the damage to their own vehicle, but also intended to give cover for their liability that they cause to others. And of course, we've seen there's a whole raft of different add-ons. But the fact that they might be generous or not generous doesn't assist in the scope or in interpreting the scope of the cover that's provided for under the liability aspect. It is the liability aspect of the cover which gives rise, which is necessary in this policy, or indeed any policy, because that's the one, that's the compulsory one. And so one doesn't get any assistance whatsoever from the generosity or otherwise. That just happens to be the bargain. The second point that arises out of that is that one needs to be cautious and careful about the liability, interpretation as to the scope of the liability cover when having regard to the scope of the other covers, because it provides for unlimited liability, for an unlimited amount. The cover that's required by way of liability cover in a motor policy dealing with liability for personal injuries is unlimited. And that is a great distinction from the cover which provides a variety of different add-ons that we see in other parts of this policy. I wanted to just pick up a point about interpretation arising out of Durham and BAI. That's the reference to that is bundle 2, tab 24, MS 839. And the point that I understood my learned friend to be making was the importance, in that case, of finding a definition of sustaining which satisfied the requirements of the Employers' Liability Compulsory Insurance Act, 1969. And reading from the holding, where it says that in any event, policies written after the Employers' Liability Compulsory Insurance Act 1969 came into force should be construed, if at all possible, as meeting employers' obligations under that Act, which included insurance in respect of negligence during the insurance period and so on. That's not an unacceptable proposition, of course, because we accept that this policy, of course, must be construed so as to meet the requirements of the Road Traffic Act, Section 1453. What we submit is that when you look at the cover that's satisfied by the certificate within that policy, the policy does satisfy the requirements of Section 1453, and then, of course, as I've submitted earlier, provides additional cover, additional liability cover. Alternatively, if you look at it the other way and look at the cover provision first, and to the extent that the cover provision doesn't satisfy the requirements of Section 1453, one then adds the Section 1453 cover in to satisfy that requirement. And that's the purpose of the certification in these types of policies, so that an insured knows that they're getting that cover. A separate point was made in relation to interpretation of clause 1A by reference to Regulation 7.2 of the Consumer Unfair Terms Act. The reference to that regulation, that act, is at tab 7 and it's MS 520.
I think you're right to call it regulations.
It's regulation.
I'm sorry, it is regulations.
It's,
It's 7
Regulation 7 at 521.
Yes, 521. And my learned friend relies on Regulation 7.2. If there is doubt about the meaning of a written term, the interpretation which is most favourable to the consumer shall prevail. In our submission, there is no doubt about the meaning of the written term. When one looks at Clause 1A, one can see exactly what it's saying and exactly what it means and what the scope of it means. There's no doubt as to the meaning. The problem for my learned friend is that it doesn't cover the incident. And so then one goes searching around the policy to see if there's an alternative, if there's other scope within the policy to fit the circumstances of this incident into the meaning of Clause 1A. But the reference in the regulations is to the term. It's not as to the policy. It's not as to the contract as a whole. And there's no unfairness, which is what these regulations are designed to overcome. There's no unfairness in our submission in interpreting Clause 1A as meaning just what it says, because, building on the submissions I made earlier, the policy which the insured has covers him for the statutory requirements and provides him with additional cover. So there is no unfairness that can be directed at that clause, and the meaning is quite clear. There's another regulation in the same bundle that I wanted to draw your attention to in the context of the suggestion that repair this language should obviously embrace repair as a use, and that is at tab 8 at 528. These are the provision and use of work equipment regulations, 1998. And I refer you to the interpretation section, where use, about 2/3 of the way down the page, is defined in relation to work Equipment meaning any activity involving work equipment, and includes starting, stopping, programming, setting, transporting, repairing, modifying, maintaining, servicing, and cleaning. I draw that to your attention because the implication in our submission from the requirement in those regulations for there to be an interpretation which involves use as including repairing suggests that such an implication is not to be drawn in relation to the regulation, to the statute which we're dealing with. Parliament has not sought to specify that use under the Road Traffic Act should include repairing. And I draw this to your attention as an example of where, when it has thought that that was necessary, it's done so. Then dealing with my learned friend's submissions on Elliott and Gray and Pumbian and Vine, I think one has to be quite careful here about the distinction between having the use of and using. And it arises out of Pumbian and Vine and Elliott and Gray arise out of criminal prosecutions for someone not having an insurance policy, where it was held that if you've got a car and it's on the road, you have the use of it. Everyone thinks about that for a moment. The fact that you've got a car and you have it on the road and you have the use of it doesn't give rise to any liability. And the purpose of Section 143 is to ensure that if you use your car in the Section 145(3) sense, you have insurance. And so you don't get a liability arising simply because you have the use of it or you have control of it or you have the management of it. We all know, and it's tried, that you then need to identify some negligent use of it, which is the Section 145A part of the equation. So on the one hand, I accept, of course, that use means have the use of, but actually one doesn't get to the statutory requirement for an insurance policy until such time as some negligence has been established and some liability has been established in your use of the car. And that's what we've been focusing on in this case. The relevant use in that sense is different from the relevant use in the sense of 143. So Elliott and Gray and Pumbian and Vine didn't really help my learned friend in his argument in that respect.
2 minutes.
I've got one question.
My learned friend's thinking, can I just mention one point? He's misstated the test under Regulation 7 because he said it turns on the words used, whereas in fact, I think I submitted it, it involves its grammatical sense and it has to be clear what the practical consequences are. And just can I just, rather than delaying you, just distribute a passage from Chitty on Contract. It's 38-350, which paragraph 38-350, which sets out the test under Regulation 7.2.
I feel sure we can read it.
And I'll hand that.
And it'll be circulated later. I'm sorry,
1 minute.
We've got a minute now.
1 minute. One final point, and that is, of course, to keep in mind also that in dealing, my learned friend was dealing with the concept of a registered owner or an owner. This concept of use and the requirement for cover applies to anyone who uses a vehicle. You don't have to be a registered owner. I'm not sure the particular relevance of 144A. You don't have to be a registered owner. You may have to have a policy if you're a registered owner. But the concept of criminalisation is one which applies to anyone who uses a vehicle. Mm-hmm. And so one has got to be cautious and apply a narrow test rather than the broader test, as I was submitting before, relying on Omani. I think I might have 10 seconds, but I won't use those.
Well, thank you very much indeed. And I'm grateful to everybody for agreeing to start the hearing earlier than normal. And we will now go away and work out what we think it all means. Thank you. Court will now adjourn.